This is a video on Iowa unemployment compensation. This is a not-for-profit video. It's not sanctioned by the Workforce Development Department nor by the state of Iowa. It's all from volunteer time. This is legal information and not legal advice. And this topic today concerns voluntary quits without good cause attributable to the employer. It's a common fallacy that if a claimant quits, they are denied unemployment benefits. There are circumstances where claimants can receive unemployment for a voluntary quit. A separate video has discussed reasons that are good cause. Today I'm going to discuss specific reasons that are not good cause as specified under Iowa Administrative Code Rule 871. Chapter 871 of the Iowa Administrative Code Rule 24.25 and the various subsections. And I want to start out with the first rule that is not considered good cause. Claimant move to a different locality. Claimant moves for personal reasons to a different location or area. That is not good cause, and benefits are usually denied. There is an exception to that where a claimant moves with a military spouse, to follow a military spouse. Now there's some difference of opinion on that. Some believe that the military spouse must be in an active service of one of the 5 branches of military, meaning Coast Guard, Army, Air Force, Marines. And I missed one in there. Nevertheless, in the situation, if moved to follow a military spouse, that does qualify a claimant for benefits. But the question is whether the spouse is a military spouse, being a civilian military or on active duty. And claimants should be prepared to argue that their spouse is in the military. Now, even if not on active duty. Let's go to the next one. The claimant left to seek other employment but did not secure other employment. Now, claimants, if you quit for another job, you have to have another job lined up if you're going to collect benefits when the job falls through. If a claimant quits without having a firm offer, that is not good cause attributable to the employer. Actually, employers won't pay in a situation if claimant quits for other employment. The employment exception is the claimant must have a solid offer and must go and actually work and earn wages from the job, or must have a solid offer before they quit, show up, and then are told that the job isn't there anymore. But quitting in order to look for other employment is not good cause and a reason to disqualify from benefits. Claimants won't win in those cases. Then we move on to the next one. It says the claimant was absent for 3 days without giving notice to the employer in violation of company rule. Many employers have policies that say 3 no-call, no-shows is considered job abandonment or a voluntary quit. Even without that rule, 3 no-call, no-shows is generally considered misconduct because it is excessive and unexcused absenteeism. Claimants will lose in those situations. Now, the next one reads, the claimant left as a result of inability to work with other employees. This concerns personality conflicts that a claimant has with coworkers. These personality conflicts are not considered good cause attributable to the employer for a quit. Employees need to learn how to get along. If you can't get along with your coworkers, it's claimant's personal problem. It's a personal reason for a separation. And not good cause attributable to the employer, benefits are denied. Now, there are exceptions to that. If an individual is being harassed by the coworkers, illegal harassment, sexual harassment, racial discrimination, and as a result, that is not included in inability to get along. This is petty personality conflicts, gossiping, and the like. Let's move on to the next. Claimant left without notice during a mutually agreed upon trial period of employment. So quitting during a trial period of employment is not good cause. Claimant has a duty to hang out, see if the trial period is going to work. Quitting because it just wasn't going to work out on claimant's part is not good cause attributable to the employer. Let's move back up. The next one, claimant left because of dissatisfaction with the wages but knew the rate of pay when hired. And this is a more common case because of misunderstandings. Sometimes claimants will start a job and they don't know what the rate of pay is at the time of hire. Then when they get into the job, they find out the rate of pay is lower than what they expected, but no promise was ever made. If a claimant takes a job and doesn't ask about the rate of pay, but is dissatisfied after they start working, that's not good cause attributable to the employer. If claimant starts a job, knows the rate of pay, but becomes disgruntled with it because it's just not enough and the work is too hard, that is not good cause and benefits are denied. It's also goes hand in hand with situations where a claimant accepts a job but knows the commuting distance, and after driving for a few weeks decides the commuting distance is too far. That's a personal reason for a quit. It's not good cause attributable to the employer because the claimant was aware of it beforehand or should have been aware of what the problems are with the commuting distance. The next one concerns incarceration. The claimant is deemed to have left if such claimant becomes incarcerated. So, and that's pretty simple. If you're in jail, that's a quit without good cause. Benefits are denied. Claimant left because lack of child care. Child care is claimant's problem. That is a personal reason for quitting if claimants leave because they can't find child care. It is not good cause attributable to the employer. Benefits are withheld. The next one, the claimant left because of a dislike of the shift worked. And that's kind of a tricky one. If claimant comes in and accepts second shift or third shift work, knowing it's going to be second and third shift work, and then quits, benefits are denied. Because claimant was aware of that. It's kind of like the rate of pay. If you know what you're getting into before you start the job and you accept it, then quitting because of that is not good cause attributable to the employer. Now, if claimant comes in and is promised first shift work, works for a few months at first shift, and then is involuntarily transferred to second shift, that may be a different story. That may be a change in the contract of hire. Not a written contract, but just the agreement at hire, and it may very well be good cause, but it needs to be a significant change in work responsibilities and work duties. The next one, claimant left to enter self-employment. Quitting for self-employment is never good cause attributable to the employer for a quit. Move on down. Claimant left for compelling personal reasons. However, the period of absence exceeded 10 working days. And there's the exception that if the claimant has the right to leave work for 10 working days for compelling personal reasons, with notice to the employer, and as long as they don't accept work while they're out for those 10 days, and then they need to immediately come back and ask for their job back, then that is good cause. But if they leave and don't come back within the 10 days, if they overextend that 10 days, that is a quit. It's a quit without good cause. Benefits are denied. The only other exception is if the employer gave them more time. So if at the point where 10 days was going to expire, claimant has an obligation to call the employer, say, can you give me a little more time? If employer gives another 10 days, they come back in those 10 days and the job is no longer there, may be good cause. Benefits may be allowed. If they overextend that 10 days, the second 10 days, not good cause, benefits are denied. The timeline is important if they leave for compelling personal reasons and exceed the 10 days. It's the exceeding the 10 days that brings forth the disqualification. Now we're talking about work environment. This is another one where just basic dissatisfaction, what's going on. It's much like quitting because you can't get along with your coworkers. It reads, the claimant left because of dissatisfaction with the work environment. Even if a claimant doesn't really understand what's going on in the work environment, the job is the job. They have a duty to find out what it's about before starting the job. Claimants need to research and investigate, because once a claimant starts a job, dissatisfaction with the work environment is not good cause and its benefits are generally denied. Claimant left because of a personality conflict with a supervisor. May not seem fair, but personality conflicts with supervisors are not good cause. Benefits are denied if you can't get along with your supervisor. Sometimes And the general rule is if the supervisor treats everybody equally bad, that's not good cause, just because they treat you in a disrespectful manner. You need to have something more than than a personality conflict to establish good cause and allowance of benefits for a quit because of a conflict with a supervisor. The next one, the claimant left due to family responsibilities or serious family needs. This is not generally good cause attributable to the employer because family needs are personal reasons. However, there are some exceptions where if you have a doctor's note and so on, and I'm not going to get deep into those because there's another video talking about leaving for family responsibilities or family needs or health reasons, and there's specific criteria that a claimant needs to fulfill in order to have it as a quit for good cause attributable to the employer. There are reasons that claimants can take personal leaves of absence to resolve family problems as long as they fulfill the basic elements, then come back and immediately ask for their job back. But as a general rule, going for a family need or family responsibility, that's a personal reason for a quit, benefits are denied. Next, the claimant left employment to accept retirement when such claimant could have continued working. Quitting to retire, retiring is not good cause attributable to the employer, benefits are withheld. Claimant would need to requalify in order to get benefits after retirement, or work another job and earn 10 times the weekly benefit amount. Claimant left to take a vacation. Claimant wanted to take a month off to go back and visit home, wherever home may be, Montana, Alaska, Mexico, Africa. Quitting to take a vacation is not good cause attributable to the employer. It's a personal reason. Claimant quit to go to school. This is a very common one. Many claimants take a job, take a summer job, and then they leave to go back to school, and you can't collect unemployment benefits if you quit to go to school. That is a disqualifiable reason and must have a requalification afterward. There have been a number of department-approved training programs where claimants can qualify for benefits while in school, but quitting to go to school is not good cause. There must be some other type of a separation, a layoff or a plant closing or something to get a person qualified department-approved training. Quitting to go to school is not good cause, benefits denied. Next, claimant left rather than perform the assigned work as instructed. And essentially refusing to perform work, that's a quit. Walking off the job because you don't want to do the job. There would have to be something there very serious to allow benefits when someone walks off the job because they didn't want to do the work. This is almost always a disqualification. The next, claimant left after being reprimanded. This is a big one. Many claimants will get angry. They feel a reprimand is not warranted. Reprimand is the same as a warning or a coaching. If a claimant quits after being reprimanded, that is not good cause attributable to the employer. Benefits are almost always withheld. This is one of the biggest mistakes claimants make, is they get mad, they think that being unfairly reprimanded is a good reason to quit, they're a good reason attributable to the employer, but it isn't. It is not. Claimants need to eat crow, even if the reprimand is unfair or wrong, and continue to go on and work as long as work is available. The next one concerns layoff. Claimant left in anticipation of a layoff in the near future. However, work was still available at the time the claimant left employment. Now, in anticipation of a layoff versus a specific date for a layoff are two different situations. If the employer says, I think we're going to lay you off sometime in the future, and the claimant says, well, I quit, I'm not going to wait for getting laid off, then that is a disqualification. Claimant doesn't get benefits. Now, if the employer says you're getting laid off on the 25th of the month and the claimant quits on the 10th, it's a disqualification from the 10th to the 25th. But if there's an anticipated layoff but no specific date for a layoff, this is a quit without good cause. Claimant loses, no benefits are allowed. Next one, claimant left due to commuting distance to the job. However, claimant was aware of the distance when hired. It's kind of like the rate of pay. If you know the rate of pay and you're at the time you're hired, or you don't ask about the rate of pay, that's claimant's problem. It's not the employer's. Benefits are withheld if you quit because of the commuting distance when you knew the commuting distance. The only exception to that is sometimes when employees are required to travel for their job. and the employer says you'll travel 60 to 80 miles. Then when they get on the job, they have to travel 400 miles because the job requirements changed. Just depends on the facts, but quitting because of commuting distance is not good cause. It's a general rule. The last one, the claimant left by refusing a transfer to another location when it was known at the time of hire that it was customary for employees to transfer as required by the job. I guess you could compare this to the military. If you take a job and you know up front before you take the job that transfers are normal, transfers happen all the time, and then the employer says you're going to get transferred and the claimant says no, I'm quit. That is not good cause attributable to the employer because claimant was aware of the potential transfer prior to the time of hire. That is just part of the job. Benefits are withheld. Now, there are hundreds of reasons why that are not good cause attributable to the employer. And the general rule is what claimants and employers should look at is, was there something about the job, something the employer did that caused claimant to want to quit? Or was this something purely personal in nature? So employers have a duty, employers should document anytime an employee quits, find out why they quit, document it carefully so they have records for it. Claimant, if they have a reason for quitting that they think is attributable to the employer, they really have a duty to tell the employer what it is, give the employer a chance to remedy the problem, and if the employer doesn't remedy the problem, then they may have a chance of proving good cause attributable to the employer. Notice and documentation are important from both the employer and the claimant's part in these quit cases. That is about all I want to tell you about voluntary quits for good cause. Well, let's go through a few more. We can go through a few more, a little bit more complicated ones before I finish up. Here's another one. The claimant left because claimant felt that job performance was not to the satisfaction of the employer, provided the employer had not requested claimant to leave and continued work was available. This usually comes up on a yearly review. Claimant gets a bad review, feels that they're not doing a very good job, and they leave. Or they feel they can't do the job because they just got started and they just can't understand computers or how to make them work, and they feel like they're dragging the employer down. As long as the employer is not telling the claimant to leave, this is not good cause for a quit. Now we get into the more complicated stuff. I'm hesitant about getting into these, but I think that you need to know what they are, and they do come up. Chapter 871, Iowa Administrative Code Rule 24.25, subsection 35 provides claimant left because of illness or injury which was not caused or aggravated by the employment and failed to. Now here's where claimants go wrong. This is not good cause for a quit if you leave because of some type of health problem. If you fail to do this, obtain the advice of a doctor, obtain certification of release for work from a doctor, return to the employer and offer services upon recovery and certification for work by a doctor. So the bottom line is if you leave because of illness,